All right, so we're here on a contempt enforcement motion. However, I don't see any exhibits from either side.
First, Your Honor, we're not seeking contempt, so I just want to make that clear. That's not something we're seeking. It's not in our petition or in our order. Number two, we did have a status conference with Judge Lee last week, and myself and Ms. Smith, both sent exhibits to Judge Lee.
Okay, she didn't send over, and I spoke to Judge Lee. She said that you all never, you discussed some exhibits back and forth and you objected to some exhibits, but she never received any exhibits to finalize what the admitted exhibits were.
Oh, I thought we had reached an agreement on exhibits, and then Judge Lee had said that hers, Ms. Smith's exhibits that I was objecting to were admitted, and that you could make the determination based on my objections. But we did send them. Would you like?
Yes, ma'am.
She needs to. What she would have needed is an email with all of or both of your exhibits.
Yes.
That you agreed to, because without exhibits, I can't move forward. Well, I mean, we can move forward. You just can't use exhibits.
I'm glad to move forward today, Your Honor.
Okay.
Well, we want to move forward as well, but I'm happy to resend the exhibits. I saw Ms. Smith's exhibits come through. I saw mine come through, and we told Judge Lee
All right, guys, listen up. We're diving straight into a courtroom drama where enforcement motions and exhibits are causing chaos. The judge immediately notices no exhibits have been submitted, and both sides scramble to clarify what's actually being requested. Miscommunication reigns as attorneys debate over what was sent to Judge Lee, and objections fly left and right. Tensions rise as the court struggles to get everyone on the same page. This is the messy reality of legal enforcement. Clarity is key, but nobody seems to have it today.
on the Zoom which ones we were okay with.
Okay. Well, before you even do all that, your client, Mr. Kincaid, he's the movant, correct?
Correct.
All right. And this is an enforcement. Let me make sure I'm looking at the violations correctly. It's 6 violations, right?
Yes.
And you're not trying to hold her in contempt. So you just want, what is it that you're asking the court to do? Because I'm not clear from your motion.
Yes, ma'am. So we're not asking for contempt. I don't believe we have anything under the family code that allows for contempt, but we do have some items that need to be returned. We've got some funds that were misused that need to be repaid to Mr. Kincaid. And then there is a Jeep Grand Cherokee that needs to be transferred. The title needs to be transferred into solely Ms. Smith's name. That still hasn't been done. And then really just an admonishment to follow the order that she agreed to.
Okay, the power of attorney, do you have it?
No, ma'am. Ms. McKnight is not my lawyer anymore.
Okay.
And I feel as she just hasn't represented me since we came to the settlement agreement. If Mr. Kincaid would simply give me the title per your...
Now, we move into the heart of the enforcement case. The court identifies 6 alleged violations, and questions arise: are they seeking contempt? The petition is murky. Funds allegedly misused, a Jeep Grand Cherokee with untransferred title, and general admonishments to follow prior orders. These are at stake. Counsel debates power of attorney, and the judge presses for specifics. All right, folks, this is where we see the friction. Parties trying to enforce compliance, but details, dates, and responsibilities are still in dispute.
Order, I will take care of that immediately. All he has to do is hand it to me.
And counsel, the reason I was asking about what it was that you wanted the court to do, because your motion is not even specific enough for me to find that she even violated the order. For example, violation 2 reads, mother has violated the order by consistently being late for possession exchange times without notice to father. That doesn't put her on adequate notice pursuant to the slaughter case about what she's supposed to do.
I think there, Your Honor, we're just looking for an admonishment on going forward to please be on time with possession.
I'm not exactly aware of the dates and times they're speaking of.
Yeah, and that's another thing. And thank you for saying that. Pursuant to Slavin, it has to allege date, time, manner. None of that is in here.
Okay, that's fine for the late times because we're not looking for any actual relief on that other than both parents need to be on time. So if we want to move forward without that one, we're happy to do that.
Okay. Well, counsel, you're. Mm.
In the prayer, Your Honor, it does say what we would like to have done.
I understand, but before we even get to the prayer, we have to get through your violation.
The judge examines the alleged violations carefully. Late possession exchanges. The court notes that vague claims won't hold up and adequate notice is missing. Both parents are warned to stick to the schedule moving forward. Counsel insists the court provide clear instructions, but it's clear there's frustration on all sides. Without specificity, enforcement becomes impossible. This portion highlights the legal precision required to hold anyone accountable without dates, times, and clear violation details. It's like trying to hit a moving target blindfolded.
And your violations.
May I speak to?
Hold on one second.
Yes, ma'am.
I don't even know how you would get there. Your violations are not even sufficient to put her on notice for the court to even grant what you're asking me to do. Does that make sense?
In which way other than number 2?
Well, I can't tell you that. I just can tell you by looking at it, is really going to be hard for the court to find her in violation when they're not specific enough to put her on notice. Have you all had an opportunity to discuss coming to any type of an agreement regarding the motion?
I have tried many times, and I know that Mr. Kincaid has tried many times to settle this matter with her. I've not received any response to our settlement offers, and I don't know if Mr. Kincaid has, but I know that it hasn't gotten anywhere.
Your Honor.
Okay, go ahead.
I have not.
In my defense,
well, you don't know.
Well, this settlement offer is adding so much more to these violations. I am at the mercy of the court right now because he literally wants so much more than what they are bringing me here today for. So no, I am not going to agree to a settlement to get rid of these items.
All right, here comes the showdown. Counsel attempts to settle, but Amanda Smith refuses, stating the settlement demand is beyond the current violations. Emotions escalate as each party points fingers, and the judge reminds everyone that enforcement is limited to existing orders. Calmly but firmly, the judge underscores the importance of cooperation over conflict. This tense exchange shows how courtroom battles can be as much about negotiation breakdowns as legal violations, with the stakes being both compliance and sanity in the process.
And it just, the settlement agreement is beyond these violations.
Okay, you all both understand that an enforcement only allows me to enforce what has already been ordered, right?
Yes, Your Honor. The problem is that's the first I'm hearing of that. Up until this point, I've had no idea what she's not okay with. So the discussions, to answer your question, no, there's not been a discussion because we've just sent offers.
You all can't talk over each other. This what I'll do. Okay, I will allow you all, if there's a conference room back there, if you would join the Zoom, I can put you all in a breakout room. That way, because the counsel, she just said this is her first time hearing it. Now, you may have had conversations with Mr. Kincaid. I don't know if it was probably translated to him, to his attorney, the proper way.
Right. Well, I just refuse.
Okay. So even after her saying that
Yes.
this was her first time hearing you say that, you're still refusing?
There have been plenty of communication.
No. It's a yes or no. Are you still refusing after
Yes.
what she just said?
Absolutely.
Okay. Joy?
Your Honor, if I may, I would like to talk to her about what we could do to resolve this. I really would. I haven't had the opportunity to talk to her.
I would like the opportunity to not have discussions with them anymore and focus on the violations at hand.
Okay. All right. So, counsel, you heard that?
The judge intervenes to mediate. Breakout rooms on Zoom are suggested so the parties can attempt resolution away from the main courtroom chaos. Everyone is instructed to focus solely on the violations at hand. It's a moment of controlled intensity. Both sides reluctantly agree to discuss specifics without dragging in unrelated settlement issues. The courtroom transforms into a controlled negotiation arena. Here, technology and judicial strategy merge to enforce order amidst high tension.
I did hear that, but that is what the settlement discussion would be about, is how to resolve the violations in front of the court today.
If I can speak to the violations, I think that we can agree. And Your Honor, my suggestions, I do think moving forward would be is somewhat of a resolution.
Okay. So, could you do this for me?
Yes.
Right? Could you speak to counsel? And it'll just be you and her in the breakout room.
Mhm.
Okay. Could you speak to counsel specifically on addressing these violations?
Mhm.
Anything else, you all can table that for right now. I just
Exactly.
want you all to speak to these violations. And I'm not trying to force anyone out of having a hearing, right?
Right.
I don't want either of you to think that that's what I'm trying to do. However, I do believe that as best you all can work together on a settlement, it just makes it better for everyone versus me telling you to do something, then you're mad because you really don't want to do what I told you to do. You'll, at least if there's an agreement, you're more inclined to follow it if you all agree to it. Does that make sense?
It does make sense, Your Honor.
Okay. So you have the Zoom app on your phone?
I do.
Okay, so let me give you the Zoom code so you can join, and then there's a conference room. It's 2 conference rooms. You can go in either one of those and go on the Zoom, and I will add you to this breakout room.
Yes, ma'am.
Let me see. And Mr. Kincaid, you're just gonna hang out here with me, okay?
Yes, Your Honor.
Right, guys, pay attention. Agreements start taking shape. Attorney Hernandez reports back from the breakout session with resolutions in hand. Simple items like child clothing and reimbursement payments are confirmed, and the Jeep title transfer is scheduled. The judge commends parties for cooperating voluntarily. An important note on self-enforced compliance. This is a turning point where communication starts replacing conflict. Even small victories, like agreeing on possessions and funds, mark critical progress in high-stakes enforcement cases.
No problem. Move to main session. Do you see me moving you to main session? Okay. So let me take you off. You can log off Zoom. All right. Okay, Attorney Hernandez, you're back.
Yes, ma'am. We were able to reach some agreements, and then we just have 2 things for Your Honor.
Perfect. You see how that worked? Okay. So let me pull your case back up. Hold on 1 second. And you all have to bear with me because the system is crashing on me left and right.
Okay.
If you all needed to go to the restroom, it's right when you go out the doors, it's to the left, and you make another left where the elevators are. You're welcome. Okay. All right. So, Joy, I can't remember. Did we? No. Okay, that's what I needed to know. All right, everyone ready to proceed? Mr. Kincaid, would you remove yourself off mute and turn your camera on, please?
Yes, ma'am.
All right. We're on the record in cause number DF 2306791. Counsel, will you please announce for the record?
Alyssa Hernandez on behalf of petitioner Drew Kincaid.
Thank you. And ma'am, would you?
Now we get clarity on representation and responsibilities. Amanda Smith confirms she's self-representing, and the court verifies everyone understands their rights and duties. Both parties swear to truthfulness. The judge reviews the progress and encourages collaboration. This section highlights the importance of legal procedure, ensuring all parties are sworn in, represented correctly, and aware of courtroom protocols. Legal structure keeps chaos in check, even when tempers flare and stakes are high.
Please state your name.
Amanda Smith.
Would you pull the microphone a little closer to you?
Amanda Smith.
Okay, and you are the respondent in this case, is that correct?
I am, Your Honor.
And you are proceeding representing yourself, is that also correct?
I am, Your Honor.
All right. Would you all raise your right hands? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, ma'am.
Thank you.
Yes,
You
Your
may
Honor.
lower your hands. So we're here on a petition for enforcement of a final suit affecting the parent-child relationship. The court encouraged the parties to speak to each other in one of the conference rooms, and it has come to the court's attention that there has been some progress, and you all have made some agreements. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Yes,
All
Your
right.
Honor.
Thank you. Attorney Hernandez, go ahead and read the agreements into the record.
Sure. And if Your Honor would like, I can not preview, but we have some agreements and then I can let you know the remaining issues if you'd like, or I'm happy to just read them if that's all you're asking for now.
You know what? Let's do it that way. Tell me the issues that remain outstanding.
Sure. So one of them is not an issue for you to really decide on, but I think both parties would benefit from Your Honor's clarification on what their order means on what a designated competent adult is. That has caused a lot of issues in their co-parenting, parallel parenting relationship. And I think both of them are seeking clarification on that.
Okay.
Listen up. Enforcement of the final suit affecting the parent-child relationship is the focus now. The court identifies progress, yet clarifications remain. Both sides request guidance on defining a competent adult for child exchanges. These details seem minor, but in reality, they're critical to safe, legal co-parenting. The courtroom drama here shows how seemingly small ambiguities in language can create major conflicts between families, requiring judicial precision and assertive intervention.